Yes, 0 hours contracts are legal in the UK, but whether you can use one correctly is a different question entirely, and that gap is where most employers get into trouble. A 0 hours contract means the employer has no obligation to offer a minimum number of hours, and the worker has no obligation to accept any work offered. That mutual flexibility is the whole point. The contract must still include a written statement of terms from day one, things like how shifts are offered, how pay works, and how the arrangement can end. One thing you cannot include is an exclusivity clause. Under UK law, 0 hours workers are free to work for other employers, so the baseline is clear. But here is where most employers make their mistake. They assume the contract type determines what rights apply, but it does not. As ACAS makes clear, rights are based on employment status, not on having a 0 hours contract. And employment status is determined by how the relationship actually operates, not by what the contract is labelled. So what does that mean in practice? So take someone hired on a 0 hours basis to cover occasional demand spikes. If, over time, they work every Monday to Friday without fail, a tribunal may look at that pattern and conclude the relationship is more like regular employment than casual work. The label on the contract does not override the reality of the arrangement. The rights that attach to a 0 hours worker depend on whether they are classified as a worker or an employee, and that classification affects holiday pay entitlement, protection from discrimination, rest break rights, and, after sufficient service, unfair dismissal protection. You cannot contract out of those obligations. If the working pattern looks like employment, it may be treated as employment, and that's the risk employers do not see coming. So here's a practical rule. Use a 0 hours contract only when demand is genuinely irregular and unpredictable. Things like seasonal cover, event staffing, on-call roles where shifts vary week to week. If the role has a predictable core, a part-time or fixed hours contract is almost always the cleaner choice. And there is reform on the horizon you need to know about. Under the Employment Rights Act of 2025, changes are expected around 2027 will require employers to assess hours worked over a reference period, likely around 12 weeks, and then offer a contract that reflects any regular pattern that has emerged. Shift notice requirements will also be formalised, so even if your current 0 hours arrangement is legally sound today, the rules are tightening. So the decision rule is this: if the work is irregular in reality, a 0 hours contract is a legitimate tool. If the work is regular in practice, the contract label will not protect you now, and it will protect you even less from 2027 onwards. If that was of value, subscribe to the channel for one real business question answered every video. For the same clarity in writing, the website and newsletter is 5minutebusiness.com.